Gahey and Associates, attorneys and counselors at law. For all of your immigration matters, call 718-263-5999 for a free personal consultation. 718-263-5999.
Hello viewers, this is attorney Naresh Gahey. Breaking news from the world of immigration. The Gang of Eight is still working very hard to get comprehensive immigration reform in place. However, that is going to take some time. I have been getting a lot of phone calls from viewers like you, wherein people are saying that isn't immigration reform expected soon? My answer to the question is don't wait for it. Why? It is going to take some time. So in a sense, keep your immigration options open. Do not wait for the new law to set in, particularly if you think you are eligible for relief. At this time, there's a lot going on in Congress with reference to changing the immigration laws of our country. And I strongly feel that this is a step in the right direction. However, it is sad to see that it is taking so long for them to debate on this bill. But by the time we debate, I would request all our viewers to continue to progress with the immigration cases rather than waiting for the new reform to set in place. So I've been asked today by a lot of our viewers to answer a few questions for them and then get to the show. The very first question from the viewer was, Mr. Gahey, do you handle cases, especially immigration cases, from all over the United States? The answer is yes. We handle immigration cases from all over the United States and the world, which means that even if you are watching this show in Chicago, in Atlanta, in Tennessee, in Alaska, in Hawaii, we can handle your immigration matter from wherever you are. The second question from the viewer is, why can you handle it? The answer is because immigration law allows an attorney to handle cases from all over the United States, except for federal matters. We can handle all your immigration matters from all over the United States and the world. Today, we are going to discuss about a very important topic, which is waivers in immigration law. What is a waiver? A common man may not understand the term waiver. Therefore, to make life easy, I'm going to make it as simple as possible so that you all can understand what is a waiver. Let's take a simple example that you came to this country and you have committed some kind of a fraud. And that fraud is very much relevant to your immigration matter. Example, you came in over here, you are married to somebody else, and after that, when you applied for immigration benefits, wherein you got married to somebody else, you went for the interview, and the immigration officer found out that you're lying to him because you were married before. So now you have committed a fraud under Section 212 of the Immigration and Nationality Act. So in order for you to still qualify for the green card, you have to apply for a waiver. Waiver means I am sorry, I committed a mistake. And because of my mistake, there will be a tremendous hardship to the US citizen or to my green card holder spouse. So let's take a simple example. As I said, you failed to disclose about your previous marriage to the immigration officer, and you're married to somebody else. And the immigration officer found out that since you had failed to disclose your previous marriage, that is a fraud. So in this case, you'll have to apply for a 601 waiver under Section 212 of the Immigration Act. Now, to do the waiver is not an easy job. Why? Because the law on the point is that you have to prove extreme hardship. And extreme hardship is a very difficult burden for people to win. Why? Because you need a lot of documentation. You need to demonstrate the hardship. Then only immigration will grant the waiver. If you do not do your documents properly, the problem is that your green card will be denied. The other form of waiver that comes in is also under 212H of the Act, and we use it especially when you see some kind of criminal activity. Let's take a simple example, right? You are charged with a crime in this country. And after you got charged with the crime, that crime happens to be a little serious. For example, it involves a crime involving moral turpitude, which means you committed a larceny and you pled guilty to a misdemeanor. And at this stage, you are getting married to an American citizen. The American citizen is ready to petition you for your green card. But the problem is that your larceny that you pled guilty to is becoming a problem. Why? Because when you pled guilty, probably you did not know that you will have immigration consequences. Probably a criminal lawyer failed to inform you that if you plead guilty to this larceny, you can have immigration issues. But now you are stuck. But still, you want to get your green card. So now, what do? A good lawyer will ensure the fact and check it up in the very beginning, before the filing of the application, to see whether you will qualify for a waiver. Then only you should proceed with the papers. Now, why this step is very important? There are crimes for which there are no waivers. For example, if your crime is an aggravated felony, that is under Section 101 of the Immigration and Nationality Act, the sad news for you is that you may not qualify for a waiver. So be very careful, even if you have been charged with the smallest crime, when you are applying for your immigration documents. You're filing for relief. You're filing for citizenship. But do you know that criminal act which you had committed can really haunt you? You take a risk and you apply your papers, and after that, the immigration officer says, I'm sorry, I will have to send you before an immigration judge. Bad news for you. Why? This means the government of the United States is commencing removal proceedings, which means deportation proceedings against you, just because of your criminal matter. How often does this mistake happen? When people apply for the papers? My answer is very often. Because the common man is not well versed with the intricacies of the legal system. And they take a chance, and the sad news is, after that, you repent, you regret. But unfortunately, there are times that even after fighting those cases in immigration court, you may not succeed. The bottom line is that if you have a criminal matter, it is good for you to get it checked up from any seasoned immigration lawyer to see whether you can have a problem with the crime that you had connected, which you had committed in the past. So folks, this is very important for you to remember that any time you have a criminal matter, be very careful. We are discussing about waivers, and under Section 212H of the Immigration and Nationality Act, if you are applying for a green card, there are some crimes for which you are eligible and you should take advantage of that. But there are some crimes for which there are no waivers. For example, if it's an aggravated felony, you committed a rape, and wherein exactly you are imprisoned for more than 1 year. The sad news is there's no waiver for that for you under the Act. So be very careful when you are filing your immigration documents. In another case which I remember, a person was married to a woman, and after that they both went for the interview, and this man went home, and thereafter it so happened he got a divorce, he got married to another woman, and he applied for his green card. He got into trouble with the law because the immigration officer said that your first marriage was a fake marriage. Because your first marriage was a fake marriage, they said that you are not going to get any relief. We are going to send you before an immigration judge and we are going to put you in deportation proceedings. So be careful if you have a prior history in immigration. A lot of people think that if I am applying for the new case, my old case will not come up in immigration. You are completely wrong. When you go before an immigration officer, you'll be surprised to see that they have every single copy of the documents that you have submitted in the past. And after that, they're going to question you about the first case first on many occasions, especially if they suspect of any wrongdoing. And only when the first case is cleaned up, then only they're going to talk to you about the new case. So the bottom line is, keep your immigration record clean in this country. If you are illegal, become legal as soon as possible. Don't wait for the new law to pass. It may take forever. But at the end of the day, be legal in the United States. Because if you get caught nowadays, you will be in immigration detention, and later on, you may also be deported from the United States if you don't have any relief. So keep those factors in mind, folks. So before we end the session, some questions and answers from people which I will be answering. So here are the questions which I've received. Mr. Gehi, I had a case wherein I went to a department store and I picked up something, and finally the police came in and I was arrested for a night, and thereafter that case is finished. Can I have an immigration problem? My answer is yes, you may, depending on what you pled guilty to. So if you are applying for citizenship, please get a check from a lawyer, because your chances are that you will be denied if you pled guilty to something that you should have not pled guilty to, or if you have other relief available in those cases, number one. Second question, Mr. Gehi, I had applied for my immigration matter in the past based upon my marriage to a US citizen. I did not go for the interview. I got a divorce. Now I'm married to another American citizen. What should I do? Your lawyer should first be checking up your old case, and then you apply for the new case. Because if you're just going to apply, and if you have an immigration fraud remark under Section 204 of the Act, you are permanently barred from applying for a green card. Be careful and get the best representation. Next question. Mr. Gehi, I am living with an American citizen. I have a child from the marriage. My husband is a green card holder. Right now, he has not applied for my green card. He was planning on applying for my green card after he becomes a citizen, but he is making my life miserable. He is torturing me mentally, emotionally, physically, every day, and I am quiet because I'm waiting for my green card. The answer to your question is, you don't have to wait. You can start your green card process on your own if you have been a victim of abuse by your spouse, even if he's a green card holder. So even if he's not a citizen, if you are living with a green card holder, you can still apply for a green card as an abuser spouse. You can see us, we've helped many people who have been victims of abuse. Even if you're a man or a woman, you can apply, self-sponsor yourself for a green card under this category. Next question. Mr. Gehi, my I-140 petition has been denied, and I am surprised. Why did the Administrative Appeals Unit deny my papers? I meet all the requirements. What are my options? I see a lot of cases wherein people are getting denied because of their qualifications, which means they say immigration states that it's a 3-year degree. That's one issue from India. And the second issue is the ability to pay from the employer. The good news is that you can file an appeal in the federal court in these cases, and you may be able to fight those cases in the federal court, and you can get relief from the federal court. We can help you if you are in a situation wherein either your H1 is denied because you got a huge RFE, or if you have received a huge RFE on your employment-based immigration matter, we can take the case over from there and we can help you to sort those issues out. Next issue was, Mr. Gehi, I'm on an H-1B right now, and the problem is that I'm about to complete my 6 years, and my employer is ready to start my green card process as soon as possible. What should I do? The answer is very simple. Start it as soon as possible, because once if you finish the 6 years, you can have a big problem. You may also have to leave the United States in certain circumstances. So be careful, be safe rather than sorry. Next question was from an L1 visa holder who said, Mr. Gehi, I've applied for the extension of my L1. And now immigration is questioning my managerial capacity of the job. What should I do? Those are very, very important issues. We help a lot of people who have been in the situation to justify that they are managers. You need to be very thorough when you respond to that query, otherwise your case can be denied because you did not prove the fact that you qualify as an L1A manager. That's a very important thing. And those issues come up, especially when you apply for your L1 for the first time, when you apply for an L1 extension, or when you're going to apply for your green card by the filing of the I-140 petition. Next question is, Mr. Gehi, I've been illegal in this country for many years. I crossed the border and I came into this country. What should I do? Take advantage of the new Obama policy. Again, I'm going to repeat, this is great news. If you cross the border, came in, if you're married to an American citizen, the good news is that the new Obama rule can help you to qualify for a green card, and every second person is taking advantage of this new rule. So the next and the last and the final question is that, Mr. Gehi, I want to apply for citizenship, but I have a criminal record. The answer to your question is, you'll have to make an appointment, come in and see me, and I'll be happy to review your immigration matter to see whether you qualify or you don't qualify because of your criminal matter. Folks, this is Attorney Naresh Gehi, and we'll be back again with some more interesting news from the world of law. Keep watching this program, brought to you by Gehi & Associates. The instant program constitutes an attorney advertisement under the laws of the state of New York. We handle immigration cases from the United States and all over the world. If you have any further questions, call 718-263-5999 for a free initial personal consultation, or email us at info@immigrationquestion.com.